Toastmasters. There's no guest, so I can proceed. I wanted to share with you tonight a few of my favorite terms from a mother's dictionary. The first one is bottle feeding. This is an opportunity for daddy to get up at 2 a.m. too, after I've had countless sleepless nights. Whoops, that's an exclamation that translates roughly to, get the sponge, hurry, get the sponge. And hearsay, what toddlers do when they hear someone mutter a dirty word. But that's one meaning of hearsay, but I wanted to share a more technical meaning of hearsay with you tonight. And I'll give you the legal definition of hearsay and some of its exceptions if time allows. The federal rules of evidence define hearsay as a statement other than one made by the declarant while testifying at the time of trial to prove the truth of the matter asserted. A short way of saying this is hearsay is an out-of-court statement offered to prove the truth of the matter asserted. And I know this doesn't make it any clearer. What does this mumbo-jumbo mean anyway? So I will break down the hearsay definition into 3 parts and explain to you what these parts mean. Statement. A statement is an assertion of fact. For example, if MJ tells Shauna, hey Shauna, I like your red car, he's asserting a fact that he likes her car and that she has a red car. I know this might sound a little circular, that a statement asserts a fact, but not all statements assert facts. For example, a question doesn't really assert a fact, but it is a question. It is a statement. So you could see that the statement has to do with something that is a fact. The second element of hearsay is that it has to be made out of court, and it's made by someone other than the declarant. So in the previous example of Shauna and MJ is the declarant because he's the one that made the statement. And if Shauna offers that at trial to prove that she has a red car, that MJ told me he has a red car, or if someone else offers it on behalf of Shauna, it is being offered, and MJ did not make that statement on the stand at that trial. But another part of this element of being made out of court, even if MJ offers that statement that, look, on the night of Friday, July 11th, I told Shauna that I liked her red car, it's still hearsay because he's not saying it for the first time on the stand. He's saying it, he's repeating what he said previously. So it's still an out-of-court statement. And I know that's a little bit confusing, but it's just that the statement has to be made on the trial for the first time, or on the stand for the first time, in order for it to not be considered hearsay. And the third part of hearsay is that it's offered to prove the truth of the matter asserted. And this sounds also a little confusing, but it's basically saying that they're trying to prove what's contained in the statement. If the statement is not true, or what's in the statement is not true, then it wouldn't be relevant to the trial. So again, in the previous example of Shauna and MJ, if Shauna is trying to prove that her car really is red, and she offers that statement, she is trying to prove what MJ said, and that would also fall under hearsay, or that would qualify as hearsay. So now that we have a better idea of what hearsay means, why do we care? And I'm sure we've all heard in a TV show or in a movie someone say, objection, Your Honor, hearsay. But hearsay also has many exceptions. So generally, hearsay wouldn't be admissible, but there's over 24 exceptions. So usually when you hear the lawyer say, objection, Your Honor, hearsay, the other attorney gets a chance to explain why they're offering it. And if it qualifies, it will be found admissible. But a few reasons why hearsay is not admissible is because the judges don't find it very reliable. They would rather hear the person that actually said the comment than someone repeating it. So, and usually when you testify, you're supposed to testify from firsthand knowledge. And if you're repeating what someone else said, you don't really have firsthand knowledge of whatever they're saying. Also, it's also because the statement was not made under oath. You weren't you could be lying or you can have a different motive for making that statement. And like I said before, there's no first-hand knowledge. So I wanted to share with you two exceptions that qualify for hearsay. The first one is the excited utterance exception. And the excited utterance exception is a statement that is relating to a condition or an event while the declarant is under the stress of an excited or startling event. Usually most statements that begin with, "Oh my gosh, look at that," or something like that will qualify under excited utterance. So anytime there is a robbery or assault or some type of, if you're witnessing a crime occur, that would fall under excited utterance exception. Another exception to hearsay is the dying declaration exception. In the dying declaration exception, it requires a statement that is surrounding the circumstances of the declarant's death. Unfortunately, the thing about this this exception is that the person actually has to die in order for it to be admissible. Because if they're alive, they can come and testify. That's how the court views it. It's a little harsh, and the other thing is that they must die from, if they describe their death that someone shot them, they have to die from the actual gunshot. They can't die 2 weeks later from other complications. So I wanted to share with you an example and to see if you think that either one of these exceptions might apply. Joe was shopping in a grocery store when he was robbed. The robber escaped just as the police arrived, and Joe ran up to the police and exclaimed in a highly excited state, "It was Linda Jones that robbed the store." The declarant Joe died two weeks later of a stroke, and the police offered this statement to prove that Linda Jones was a robber. Do you think the first exception would apply, excited utterance? Yes. Okay. There you got a consensus. And do you believe that the second one would apply, dying declaration?
No.
Okay, that's correct. The excited utterance because it was an exciting or startling event, and the dying declaration didn't apply. So in closing, I wanted to share with you one real-life example of a hearsay objection. The LA defense attorney for Charles Manson, named Mr. Irving Kanarek, who was known for dragging out cases with long speeches and continuous objections, made this objection. He once objected when a witness was on the stand, was asked to state their name for the record. He objected to this because the witness first heard his name from his parents, and that was considered hearsay. So people can get pretty ridiculous with these hearsay objections, but I just wanted to share with you tonight, and I hope that now you're a bit better informed of the hearsay definition. Thank you very much.